Welcome back to the One Take Show, a podcast where we celebrate incredible conversations with some fantastic people. Ladies and gentlemen, joining me in this amazing episode of the One Take Show is Mr. Ishaan Madaan. Sir is an international arbitration lawyer. He is also the founder of Arbinsol. He is an FDI Moot scholar, and in this episode, he is going to talk about his journey with law. He will talk about his experience with University of Miami School of Law. He will also talk about his experience with New York State Bar and why is it essential for law students, especially in India, to explore these opportunities. Finally, we will talk about what is the interplay between arbitration and insolvency, which is now affecting the global legal pedestal. We will also talk about Arbinsol as a venture and what all opportunities does it open up for various law students and legal aspirants. Stay tuned to the very end of this episode because these are the kind of conversations which really change our perspective about the latest legal developments that happen around the world. Hence, ladies and gentlemen, without further ado, let's jump right in. Hello, sir. Welcome to the One Take Show. I should not be calling this a One Take Show. This is perhaps the Two Take Show now because the Zoom decided to play with me, and the entire setup that previously we've had got scrapped. But I'm so grateful to have this opportunity all over again to talk to you. I think all these technological handicaps that we face in our daily life will never stop me from taking this opportunity to learn from your wonderful experience, to talk about everything that you have achieved, everything that you've accomplished, and perhaps take this beautiful conversation that we're going to have to every listener and every law student who can benefit from your journey, who can benefit from your achievements. So thank you so much for taking time off for this beautiful conversation that we're going to have.
Thank you so much, Kaustubh. That's very kind of you. And whether it's one take or two take or three takes, it's always great catching up with you. So I'm glad I'm having this opportunity again of talking with you. And of course, I'm delighted to share whatever experiences I've had so far. So yes, let's go on.
The same here. So before we get into the conversation, which I'm really excited about to discuss all those multiple things that we can most certainly, there are the arbitration, the insolvency, the interplay between the same. We'll talk about Arbinsol. We'll talk about there are tremendous exciting stuff that is coming up in this podcast. Before we get into that, I would love to talk about your journey with law. I believe your journey in law school has been very exciting. That post that your years in practice has been must have given you a lot of perspective with life. We would like to learn about your journey and how did you arrive at various achievements and accomplishments that you did.
Well, that's kind of you. I'm still a learner. That's what I would say. And my journey through law school was quite exciting because it was quite unusual. It wasn't like a regular law school journey that most students have or tend to have, although they say that law students do not necessarily have easy or good journeys, but most definitely mine was a different experience. So not many people know, but for the last 2 years of my law school, I was mostly bedridden because of some illnesses. And that perhaps gave me a more hands-on real life experience to go about issues and problems and challenges. And initially, I'd always thought of becoming a corporate lawyer, getting into transactional practice. And in fact, all the internships I'd done were mostly concerning corporate practice. In fact, I was back then, I remember working with the former president of the Institute of Company Secretaries of India.
Okay.
And I'd always thought that I would, just like a regular law school student, I would work hard, do well in the internships, get a pre-placement offer, and have a good, nice paying corporate job. But I believe life had different plans. And that period of being bedridden, in fact, gave me the impetus to explore dispute resolution as my area of core practice. In fact, right after law school, I had gotten an opportunity with a tiered law firm in Delhi, and I was working as an associate in their corporate department, and I was doing a lot of due diligences. And within 2 months, I realized that, I'm probably not cut out to sit behind a desk and do my practice from here. So I took the plunge and I decided on getting into dispute resolution.
Right. And after that, like you entered into the litigation field, what was your experience like with practice of law? And how did that, in a way, inspire you to move ahead with LLM that you did with University of Miami? And what was that journey like?
So, well, from then to now, it's a 9-year
Mm-hmm.
journey so far. I
Okay.
started working with an advocate on record at the Supreme
Mm-hmm.
Court of India. And to my fortune, he was so occupied with work, with such little stuff,
Mm-hmm.
that starting from the third day of me joining him, I had the opportunity to start appearing in court by myself and
Okay.
making submissions. And that initially was scary because you've
Mm-hmm.
never done an internship in courts. You wanted to be a corporate lawyer, and suddenly you're in
Mm-hmm.
court and you're asked to make submissions to the court, and that to the Supreme Court, and it just
Right.
scares you.
Mm-hmm.
But incidentally, what happened is that that gave me a lot of confidence. It
Mm-hmm.
took away a lot of fears because, of course, a lot of lawyers, they say that even after 10 years or 15 years into practice, if
Mm-hmm.
they are up against a bench, they still have those jitters and fears at times. And I was fortunate that I was just, pushed into that sphere where I had to take the plunge and
Mm-hmm.
learn how to swim, and that
Right.
really helped me initially. And then thereafter, I started appearing a lot. I had a diverse platform
Mm-hmm.
because of the diversity of cases that he had to go
Right.
out and explore different nuances and explore both civil and at times criminal litigation.
Right.
And that allowed me to go out and explore what there is, and that craving that a young lawyer has, that I have to see how it works, I have to contribute to someone's life, I have to create
Mm-hmm.
value in what I do. And that
Mm-hmm.
really helped shape the path that I was looking for.
Mm-hmm.
And to say that, oh, I had clarity what's going to happen 2 years
Mm-hmm.
or 5 years or 10 years down the line, I won't lie about it. I was still exploring because I just come out of a phase where the basic concern for me was to survive the illnesses.
Mm-hmm.
And therefore, after that, I was like, okay, life is just to explore different things. Life is to explore what you can do.
Mm-hmm.
And then step by step, I kept taking it on. In fact, one pivotal point came in my life when a very dear friend of mine, his father reached out to me and said, I have this big investment that I made in a real estate project.
Mm-hmm.
And I'm looking for someone young, someone
Okay.
enthusiastic, who's willing to learn and who's willing to explore what can be done
Okay.
with law
Okay.
being at the core.
Okay.
And that was a very, very eventful journey, must I say, because
Mm-hmm.
through that phase of investing 6 to 8 months in just research and not filing a single case,
Mm-hmm.
and just exploring the nuances of law and how it can help me understand that litigation is just stage performance. There's a lot of work that goes behind it.
Mm-hmm.
There's a lot that you can actually understand and preempt in
Mm-hmm.
advance at times. That it's like playing a game of chess. You calculate your moves and you go ahead with attempting to do something successful. And how
Right.
that helped was that they had been trying to chase that real estate developer for good 3 years back then.
Mm-hmm.
But with the kind of work that we did together, they were down at the table within 6 months for a settlement. And that, in fact, became something that blazed the trail for many more investors there. And that gave me a reassurance that, yes, litigation is what I want to do. And
Perfect.
after that, speaking of how I came to the stage of LLM, I collaborated to set
Mm-hmm.
up a law firm in 2015, and we were
Mm-hmm.
doing a lot of arbitrations. We were doing a lot of corporate and
Mm-hmm.
commercial litigation back then. I
Right.
was fortunate to be associated with some leading arbitration counsel in India,
Mm-hmm.
and I got the opportunity at times, a push from them, to go
Mm-hmm.
ahead and argue those cases as first chair on some
Mm-hmm.
instances. Fortune favored that I was also appointed as an arbitrator by the Delhi High Court in a
Okay.
commercial matter.
Okay.
And simultaneously, I explored the opportunity, and I was invited to arbitrate at the FTI Moot in Boston in
Right.
2017.
Right.
And that opened my eyes to an environment
Mm-hmm.
far wider and broader than what you get to see sitting in a home jurisdiction. It was like, if I have to take this step up and if I have to understand the nuances, how international dispute resolution works, it's very important to step up and go and explore an LLM.
Right, right. One question, although I believe you've already answered this, but there's one question that runs in the mind of any fresh legal aspirant is, how useful is an LLM when it comes to coming back in India and practicing again in litigation? I understand with respect to international arbitration, it is quite useful because it opens you up for multiple opportunities. But in general, what is your opinion on the utility of LLM as a course for lawyers?
See, there are countless factors that go in. A big factor for everyone has to be money,
Right.
whether or not one can afford an LLM program or not. Then, of course, the issue of utility,
Right.
whether it's going to add any value or not. Like whatever you study in LLM, it's not that you cannot access that on online platforms and you cannot extract that material from some good libraries. All that knowledge, all that information is available. So you don't necessarily, one may say, you don't necessarily need an LLM. Whatever you've studied there, you can definitely sit at home and study, and probably in lesser time.
Okay.
But more important than that is the environment.
Yeah.
Which gives you an opportunity to expand your life, to widen your thinking. Everything rests here. It's here from where you perceive life and from where you perceive your profession. And if you can get an opportunity to open your mind to different cultures, to different practices, to different approaches, I think it really adds a lot of value to you as a human being, to put yourself outside your comfort zone in an environment where everyone has come afresh with some kind of ambition, with some aspirations, and mostly with a zeal to learn something new. So that gives you a wider and broader platform to explore yourself, both as a professional and as a human being. So I think for any young student, when he's considering the option of LLM, he has to, and definitely that student, he or she has to look at the different avenues of value creation that the student is going to get. And I also believe that if you put your mind to something, you can definitely get scholarships, you can definitely get some funding arrangements. But the first and most important thing is to make up your mind.
Right. I think that's absolutely perfect. No better way to define the utility of LLM than to actually listen to someone who's actually gone ahead with this decision. I think what you point out with respect to exposure and actually going out in an environment that is going to add the tremendous kind of value is extremely important. I will take this conversation to a very unique sphere where I would love to ask you about your experience at University of Miami, and with respect to that, your experience with New York Bar. I think I can only imagine how difficult that entire journey would have been, but how celebrations would have turned out after you would have cleared the New York Bar. How was that entire journey like? I'm just really fascinated with this idea.
Well, the most important word, or rather the pivotal word you used there, was journey.
Right.
So it definitely was a journey. I joined the program in the middle of the program, in the sense it's usually a fall start, but I joined the program in the spring semester because I had some assignments back in India that I had to get done with, and I asked for a deferred start, and they allowed that. I'm very kind with that. And coming here, it's like you're put in a super star-studded environment. The professors that we had are renowned academicians, are renowned practitioners in US and Latin America. We had professors visiting us from Europe. We had the now late Professor Rudolf Dolzer, who's considered an authority in investment arbitration, investment law. We had Professor Jan Paulsen, who was the professor chair of the program at that time. And one of the primary considerations why I chose Miami to pursue my LLM. And here, of course, you're literally put on a fast track immediately. As soon as you arrive, as soon as you start, things are just going in a blaze flash manner. And you have your weekly courses, you have your courses that run for say 2 weeks, 3 weeks, 4 weeks, and simultaneously have other courses. In the meanwhile, you get opportunities to write for the Arbitration Institute here. You can act as a research assistant with the university. Those are opportunities that I got. Over the course of time, I got a very special opportunity to do a practicum at a leading tiered, tiered law firm, which does a lot of international arbitration. So that was fantastic that I
Right.
actually got to work on an ongoing international arbitration while I was pursuing my LLM. And another great opportunity that I got was to contribute to an amicus brief that was filed before the United States Supreme Court on a very pivotal issue, a very important issue of compelling arbitration or compelling a non-signatory to an arbitration agreement
Right.
to arbitrate. So that was a fantastic experience, and to our fortune, that was allowed in favor of the proposition by the United States Supreme Court unanimously.
Right.
So these were opportunities that I got during my LLM program. And as soon as you start with the LLM, you also have to think about the New York bar, whether or not you want to take it. And for students and youngsters like me, who would be exploring the option of sitting for the New York bar, it's very important to know that the documentation process starts as soon as you get here, because you have to turn in a lot of documents from your home university and your home jurisdiction, which have to be sent directly to the New York bar from your respective university and your respective bar if you're a licensed attorney in another country. So all of that has to be managed, and then begins your application process. Simultaneously, without knowing whether or not you'll be able to sit, you also have to start studying for the bar.
Right.
And Miami Law, incidentally, offers a program which is very centric to the bar exam. So during my LLM, I was also preparing for the bar. And during my LLM, I was also associated with the FDI team of Miami Law. I was assisting the lead coach there. And so it was a roller coaster, the entire LLM year. But then began the actual journey of preparing for the New York bar, which is definitely a journey. It's not an easy experience if anyone thinks, oh, it's just a bar exam, I'll go and sit and study. Some people say New York bar is one of the toughest bars. It's not the toughest bar, but it's definitely that requires you to burn a lot of oil. And it's different for students who have pursued a JD, a Juris Doctor program here, because you study those subjects over a course of 3 years. But for a foreign student, you have a limited bandwidth because you just have to go through your LLM, which requires you to spend your time on your core master subjects that you came for. Simultaneously, you have to study some subjects during your law program, which constitute or which are part of the LLM, which are part of the New York bar course. So you're tested on about 15 to 16 subjects. And it's very limited time. They have commercial bar preps here. But what I can say about the preparation phase is that it burns you out. It demands a lot of time. It may, even make people think why they took up law as a profession. It may even make people think why they decided to take the New York bar as a foreign candidate. What's the point? Why do you have to slog so much? But it's an internal journey. It's like you're put in a position. You yourself put yourself in a position.
Right.
And then you question, why am I here? What am I here for? Should I be doing this? Should I even pursue law as a career? Should I, think of being in New York as an attorney? But all of that also becomes a great journey, which really pushes you to work harder, which really tests you on a lot of factors. So the New York bar is not a test of your academic, your academic temperament or your academic understanding, but it's more of a test of your practical temperament, of how you can actually approach a given set of laws in a limited time crunch, and how you can just sit for those 12 hours across 2 days and write that exam.
Right.
And talking of celebration, I just passed, the results came in when we were in the middle of the pandemic. So the
Okay.
biggest celebration I had for myself was that I felt a lot of gratitude that I cleared the bar
Hmm.
before
Hmm.
they canceled the bar exam twice.
Wow. Yeah. So I think this is a very inspiring journey of yours. I think the fact that we've talked about, you've said that this journey involves a continuous self indulgent sort of a motivation that comes from inside, where you have to keep burning the oil and you have to keep studying for the examination, which is one of the toughest examinations in the world. Following up to one of the questions that I really wanted to ask, you've mentioned that while you were in University of Miami, you had an experience with international arbitration. Previously you mentioned that you've also had an experience as an arbitrator. So having the experience from both sides of the bench, how was that this dichotomy working for you?
I mean, I won't really call it a dichotomy.
Hmm.
When you're wearing the arbitrator's hat,
Right.
you get a lot of responsibility
Hmm.
that
Hmm.
you have to decide, that you have to decide on the facts involved, that you have to be wary and careful, that you pass an award that is enforceable,
Hmm.
that you pass an award that takes into account all the factors involved. And through my experience, I would say through my experience of arbitrating at various moot courts, at least I got glimpses of how one should act when you're sitting on the other side.
Right,
But
sir.
talking about, at the heart of it, we are counsels. At the heart of it, that's what we've been doing,
Hmm.
arguing cases and arbitrations. And in fact, I would say the most cherished experience would be participating in that international commercial arbitration, because then you see how it works in a in a setup which has multiple jurisdictions involved,
Right.
how it works in a setup where you have contractual obligations flowing from
Hmm.
different countries, and then you have a seat for the
Hmm.
arbitration, which is a third jurisdiction altogether.
Hmm.
So, I won't call it a dichotomy. I would just say diversity of experience.
Wow. Right. Right. Well, that's wonderful. I had that doubt in my mind. I think I just really wanted to know how would you have felt on both sides of the bench. This brings me to the rather interesting phase of our conversation, where we talk about the substantial discussion of insolvency and arbitration, international arbitration, the interplay that goes on here. But to lay a strong premise for the same, I think I would love to talk about this new venture of yours, new enterprise of yours called Arbinsol. I'm very tremendously excited for this process that Arbinsol is trying to propagate, the knowledge it is trying to disseminate amongst the law students. The idea of interplay between arbitration and insolvency is extremely exciting for someone like me who finds deep interest in this subject. So, could you please tell us about Arbinsol? What exactly is the principle behind Arbinsol, and what is the message that you're trying to convey through Arbinsol to your consumers who use your knowledge that you disseminate and consume the content that is being created by all those rich panelists that we see on Arbinsol?
So the idea of Arbinsol came from some research that I'd been doing
Mm-hmm.
while as a student at Miami Law. So, as I said, one of the prime reasons to come to Miami Law was to, study from Professor Jan Paulsen. And to
Right.
get into his class, we had a
Mm-hmm.
necessity that you have to write as a qualifier, that you have to write a paper proposal.
Mm-hmm.
So while I was in India, I was doing a lot of insolvency and bankruptcy matters as well. And
Mm-hmm.
I could sense that insolvency is something that is very vulnerable to abuse.
Mm-hmm.
And the extent of abuse goes as far as stalling any kind of litigation or dispute resolution proceeding against that purported insolvent entity.
Mm-hmm.
So I was a bit concerned about how this would pan out, and I
Mm-hmm.
thought it would be interesting to write about it. It would be interesting to explore this interplay or this
Mm-hmm.
conflict that comes about between these two conceptually different fields. And I wrote that paper while I was at Miami Law. I was awarded for that paper, and that made me think
Wow.
that wow,
Mm-hmm.
this conflict is definitely something worth investing myself more and more in,
Mm-hmm.
because the more I try to explore this conflict and this interplay, uh, the more I discovered that it's underdeveloped so far.
Mm-hmm.
And we did a lot of, so I was also the secretary of the student association at the LLM program. And we, as the student association, also organized a few seminars, a few panel discussions on this. And right after I graduated and I took the New York bar, the pandemic hit. And something that was just, an area of interest for me to study is now becoming a practicality. And even before the pandemic came about, I was also, I'd already started working on a book with a dear colleague of mine who's a professor at Ginger Global Law School, with whom him and I, we together formulated this idea of exploring this avenue more and more, and all the nuances concerned around it, whether it's security for costs, third-party funding, issues of arbitrability, issues of harmonization, and all these things. Collectively, we thought that it's important now to have a discussion and dialogue about it, because when I perceived Arbinsol, which is a platform to encourage research, discussion, dialogue, debate, and eventually thought leadership on this interplay. Everybody then was just talking about force majeure. Everybody was talking about how arbitrations will be in the future. But I realized more important than that is to understand how this conflict would play out when all around the world businesses are on the brink of insolvency. We keep hearing so many big names across the world filing for bankruptcy, seeking protection under the law. How would that pan out when those parties are already signatories to arbitration agreements? How would those arbitrations proceed when they come up? Or what would happen to arbitrations when they're already ongoing and a party has gone insolvent? And what would happen to the award? There is so much that has to be done in this regard. And given that we were already doing some research and we were already in the process of writing a book, and we already have some academicians backing us as thought leaders, we believe that it's very important to bring this discussion forward and to get academicians and professors and practitioners from around the world to come forward and talk about it. And that's what Arbinsol has been doing. And we're so fortunate that, some great industry leaders and academic leaders from around the world are coming forward and, giving us the privilege to learn from them, with the world actually witnessing how that knowledge goes about.
Right. I think the entire idea behind Arbinsol itself is so exciting. We've had one webinar recently, which I genuinely enjoyed the kind of discussion it was trying to propagate. The idea here is that the interplay between arbitration and insolvency is to be celebrated in academic discussions, the kind of panel that can only be provided by Arbinsol. So anyone who's interested in arbitration and insolvency as an interplay would most certainly find Arbinsol as an indispensable mode of knowledge dissemination and a platform that can actually give us the kind of information that we need. This gives me an opportunity to talk about arbitration and insolvency. You've recently shared with me one of your articles on Clover, which was extremely exciting. Like, that article summed up my entire research for Justice R.K. Mood. that article gave me a lot of understanding, very deep into what exactly is the interplay with respect to arbitration and insolvency. So on a very general tone, if we were to ask you what exactly is this interplay that we talk about, and with respect to issues that come up with insolvency being imposed on a certain party in different country, with respect to international arbitration being instituted in some different jurisdictions, what exactly is this interplay?
So, as I was mentioning, and I try to keep it short and crisp. Arbitration is something it's a creation of consent. Arbitration arises out of party autonomy. Domestically, it's still subject to domestic laws. But if you speak of international arbitration agreements, eventually you have to look towards the New York Convention for the purpose of enforceability of an agreement, for the purpose of enforceability of an award. Now, if you have businesses or entities from different jurisdictions coming forward and doing trade and business, arbitration provides an assurance, or at least a sense of assurance, that yes, if things go down south, you still have the opportunity to have access to justice. You still have the opportunity to resolve disputes. And the convention, it binds the 163 signatories that it has, compelling them to enforce an arbitration agreement or an arbitration award as long as it meets the tenets of the convention, and as long as it's within the boundaries of public policy. Now, this public policy becomes a concern, whether the public policy to be applied by a court has to be domestic public policy, or it has to be transnational public policy, or it has to be international public policy.
Right.
Now, insolvency, on the other hand, is a governmental policy. It's a governmental measure for domestic economic objectives. Insolvency laws vary in different countries, but the one thing that's centric to insolvency is that businesses are given an opportunity to reorganize themselves.
Right.
Which requires that you abate all litigations and arbitration and other proceedings against that entity. But then it makes a different kind of sense when it's done just domestically. But it becomes kind of different when the implication of that domestic measure goes directly to an international arbitration or an international arbitration agreement, where the other party from another jurisdiction did not foresee that your domestic measures might be abused. You might abuse it yourself. You might seek assistance in getting the insolvency triggered. Someone else might do it, and that would therefore compromise the entire journey of arbitration. In the sense, if the destination is compromised, the journey makes no point.
Right, sir.
So that kind of becomes defeatist for international arbitration.
Right.
Plus, there is lack of clarity with the tribunals at times whether or not they should proceed with an arbitration, with an international arbitration, when the party has gone insolvent in its home jurisdiction. There comes the issue of capacity. There comes the issue of who is going to represent that insolvent estate. There can also be instances where the claimant himself or itself becomes insolvent.
Right.
And then in such scenarios, how do you enforce an award against an insolvent entity? Should someone, should a party to an international arbitration that has, spent millions and has undergone so much process to get a decent award in their favor, suddenly standing at the end of the queue with, in Indian terms, we say an operational creditor?
Right.
So there is need for some harmonization here. There is need for, at policy level, at some legislative level, there is a need to bridge that gap. And during and after this pandemic, there's going to be a lot of issues around that. And if you hit a dead end all the time, then that's going to be a big blow for international trade and commerce. And that's something which wasn't really probably foreseen when the convention was adopted. When the convention was adopted in 1958,
right,
broad issues of public policy were addressed, but insolvency as a core issue was never debated at large. And therefore there's a need to revisit that, and therefore there's a need to harmonize that. So this is the interplay, this is the conflict, this is the interplay, and there is a need for harmony between these two independent domains.
Right. So I think this entire issue, this conflict, also the interplay, is much bigger than just the issue of moratorium and suspension of the arbitration proceedings. It is more about the interplay with respect to the capacity, with respect to the representation, and multiple such facets. I think this entire conversation about arbitration and insolvency is so rich, and will give us a direction that we need to look into. A lot of my friends I know are very excited to read up about international arbitration, dispute resolution, and their interplay with insolvency, bankruptcy laws. And I think this conversation is going to help a lot of such listeners who are trying to understand these concepts, or perhaps get introduced to the idea of this interplay that arbitration and insolvency is. So I think this conversation will add tremendous amount of value to anyone who tunes into this podcast. Do you have any closing remarks for our listeners?
Well, I would also invite your listeners and my colleagues that if anyone wants to delve deeper into this, if anyone wants to contribute to some aspect of research, some nuances that they come across, something a new perspective, perhaps. In fact, we're also starting to invite research and publications, and in fact, for law students, we're also offering positions as research assistants or as interns to come forward and participate in this process, which hasn't been done at large in the past, but something that can be done at a unified platform. So that is just regards that interplay. But as regards our conversation, must I say that I'm always delighted to see your jovial face. I'm always delighted to know about the kind of work that you're doing. And in fact, I would not shy away from saying that, you did play a part in inspiring me to take Arbinsol online, because the way you've been holding these talks and you've been holding these podcasts, I really felt inspired that, the young Kaustubh that I met 2 years ago is now, taking the international lawyers sphere by storm by getting such good panelists, by getting such good speakers. And I've been following your work. I've been following the kind of eminent faces that you've been having on your platform.
Thank you.
And I'm really delighted with the work that you're doing, and it gives me immense joy, and I'm sure it also inspires a lot of other students and young professionals to make the most of this lockdown and sitting at home and making it more productive.
Right.
So hats off to you.
Thank you so much. I think that's it. That's the recording I needed. That's the validation I needed for this entire project where I started for. Good thing that got recorded. But thank you so much. I think this is the principle on which the One Take Show is based on. The idea to take such brilliant conversations with such brilliant individuals to everyone who can have access to such conversations and perhaps learn something new out of this. I had a wonderful time talking to you. I hope you had a good time too.
It was my pleasure.
Wonderful. Thank you so much. So I think Arbinsol as a platform will always excite a lot of law students. A lot of law students who, like me, are interested in arbitration insolvency will move towards Arbinsol, will perhaps apply for all those exciting internship positions that I personally am going for, and all those research projects that we can be a part of. Thank you so much for taking time out for this wonderful conversation.
Thank you so much, Kaustubh.
Thank you, sir.